On April 21st, the Patent Office published an advance notice of proposed rulemaking that proposed substantial changes to the rules governing administrative review proceedings before the Patent Trial and Appeal Board. To say that this rulemaking is of intense interest to many of my constituents would be a dramatic understatement. Ms. Vidal, as you noted in your testimony, there were over 14,000 public comments from stakeholders, which I understand to be an unusually large number. I know you responded earlier to questions from the chairman that spoke to not just the large number, but thoughts on how to address many of the concerns expressed in that public comment, pathways forward, and the timing of proposed rulemaking. So I won't be repetitive with those questions, but I do want to also acknowledge our former colleague, Senator Leahy, who recently wrote 2 op-eds critiquing the rulemaking as exceeding the Patent Office's statutory authority and conflicting with the America Invents Act. And I'll quote from Senator Leahy. He says, "I can say with absolute certainty that the proposed rules directly conflict with the legislation on a variety of matters, especially on provisions that limit access to the PTAB." And he points to the proposed standing requirements for PTAB proceedings and shortening the deadline for filing a petition for review from 1 year to 6 months. So just given that and more of the concerns I'm sure you've heard, wanted to afford you an opportunity to respond to those viewpoints.
Thank you, Senator. In terms of what was in the ANPRM, they all fall within the USPTO's authority, including those under 35 USC 2B, 2A, 314A, 316A2, A4, A6B, 317B, 324A, 326A2, A4, A6B, and 325D. That said, it is not clear that we are moving forward with all of those proposals. As I mentioned earlier, the proposals in the ANPRM serve 2 purposes. Some of those proposals really codified our existing practices, which we've received positive feedback on and which are actually becoming very effective. And they provided the option for stakeholders to suggest changes to those existing practices. The other proposals in the ANPRM were ones that came from stakeholders, and instead of the USPTO making a decision without data, we decided to float all of those in the ANPRM so that we could receive data from stakeholders and determine what to move forward on. So in terms of where we're going from here, we do I plan to release something soon on what we have decided based on the comments we're not moving forward on, so that people can focus on the areas where we are planning to potentially make a difference, and then we will move forward with the NPRMs on those topics.
Okay, that's helpful. Thank you for that.
Thank you.
I also wanted to ask a follow-up question on something Senator Hirono raised, and that's the value of diversity in inventorship. She spoke to gender and ethnic diversity. Research has also found that inventors are becoming increasingly geographically concentrated. A National Science Board found that in 2020, 41.6% of U.S. counties had 0 patents granted to people residing in that county. And as representative of California, I know that the general Bay Area and the Central Coast appears to be very well represented in terms of patenting. The Central Valley of California and other regions in our state, for that matter, are not. So could you speak about the importance of meeting potential inventors where they are, with research showing that inventors are increasingly concentrated, as I mentioned? What steps are we taking to extend participation in inventing and patenting in communities across the country?
I'm very focused on that issue, and I'll just tell you some of the things we've done already. So I brought together our regional offices in Colorado in July to talk about how we could better use the regional offices to have more reach within the regions. Beyond that, as part of our Council for Inclusive Innovation, we're starting an IP Ambassadors program so that we can use all of our great employees in every state. I know we have 385 employees in the state of California dispersed throughout the entire state. They could then work as ambassadors and work with communities to be there and support innovation. In addition to that, we have patent, trademark, and resource centers and libraries around the country. I've started sending individual letters to each of the libraries where we don't have a PTRC and asking them to join the PTRC program so that we can bring patent and trademark resources into communities. I immediately got a response from Virginia Tech, who signed up immediately. They're a minority-serving institution, and so I'm looking forward to doing more and to making sure that I'm reaching every university that has a library, including community colleges and ones in remote areas, so that we can bring those resources to them. That's just a little bit of a flavor for the work that we're doing, but we are very adamant that we need to get everywhere, including, I will note, to military bases. I'm going to military bases across the country, and I'm going to Delaware soon. I've been to North Carolina. I've been to a number of states, not hit California yet, but I've been to Hawaii and met with military bases, worked with the schools on innovation training, worked with the military service people, their spouses, veterans, on how to be part of the innovation ecosystem.
Okay. Well, you have an open invitation to come to California. Look
Yes.
forward to welcoming you there.
I get there once in a while.
Thank you, Mr. Chair.